in 2009. I've been through 2 election cycles. The City of Bexley has always been very gracious to me. And so I want to thank the organizers, my Harmony Project sister, Jen Mormon Robinson, for inviting me. And I'm looking forward to dialoguing with everyone tonight.
Wonderful. Thank you so much. And Judge Beatty Blount, thank you so much for joining us. You could tell us about yourself.
Thank you for having me also. My name's Laurel Beatty Blount. I actually grew up very close to Bexley in the Eastmore area, in between Maine and Dale. I went to St. Catherine's Elementary School 1 through 5, then went to Columbus School for Girls 6 through 12, graduated from there and went to Spelman College in Atlanta, Georgia. From there, I went to law school at Vanderbilt University School of Law in Nashville. After law school, in this order, I did big firm, medium firm, small firm, and then went to be the Director of Legislative Affairs in the Ohio Secretary of State's office, who at the time was Jennifer Bruner. A very exciting time in my life. I went from applying the law to being on the side of making the law. And during a presidential year, actually. I thank you for being here. I was on the Common Pleas General Division bench for 10 years, from 2009 until 2018, when I ran in 2018 for election to the 10th District Court of Appeals. And so I went from General Division, having adult, criminal, and civil over 15,000, to the 10th District Court of Appeals that all of the courts essentially appeal to. So now I have criminal, adult, and juvenile. I have all civil, probate, domestic relations, as well as appeals from administrative agencies that oftentimes are from around the state, because the administrative agency that they're dealing with is actually in Columbus. So that gives the 10th District jurisdiction over those cases. I have been active for a very long time, and very passionate about voting and why people should vote for judges in particular. I have been, in the last several months, been doing a lot of education about the court system itself, what court does what and who goes where. And it's something that I very much enjoy, because I think the public needs to know and be informed voters about who their judges are.
Absolutely. I had the privilege of actually having a mutual friend share some education you gave in the last 24 hours on all the people in our lives who are elected. So that's wonderful. Thank you so much. So for the community, I want you all to know that the chat is now closed, but the Q&A option is there. So we do have some prepared questions, and near the last portion of today, we will open it up to asking some of those questions that the community gives us as well. Thank you so much.
So with that being said, good afternoon, everyone. My name is Manika Williams, and I am the co-moderator with Miss Becky Guzman. And we are so excited that Jen and Monique came up with the idea to create a platform for us to have a community conversation to help raise the awareness of the justice system and how systematic racism impacts the lives of the people that get arrested and then having to navigate the justice system. So with that being said, our first question is directed to Judge Cocroft. Ma'am, if you could please explain briefly how a police encounter that results in a criminal charge moves through the court system from mayor's court to the Court of Appeals. Please include anything around arraignment, bond, motion hearing, trial, the plea, and the sentence. And then when you finish, if either Judge Blount or Mr. Shannon would like to weigh in on that, we would appreciate it.
Well, thank you so much. That is a packed question, because it is a fairly lengthy process, although it seems that it could be move quickly or robustly. So I will speak specifically from the experience of working in the General Division, the Court of Common Pleas, and how that process works. So once someone is arrested, there is generally the opportunity for them to be summoned in for an arraignment, or if they are arrested, they can be held in custody and then arraigned. There are certain days on which arraignments take place in the Court of Common Pleas and the municipal court. Those arraignments can be handled by one of the 17 judges in the court, or the other option is to have the arraignment handled by our magistrates. Generally, magistrates handle civil matters with permission of the attorneys who are handling a case on behalf of litigants, but we also give them responsibility of managing arraignments. Arraignment is the formal process through which a defendant is made aware of the charges against him or her, and he or she then has the opportunity to enter a plea. Generally, that plea is a plea of not guilty, and that is really what triggers the whole process of getting before a judge. At that arraignment, there is a bond that is set based on the nature and circumstances of the crimes charged, the allegations against the defendant. The state of Ohio prosecutes all criminal matters through a county prosecutor. Of course, here in Franklin County, that's the Franklin County Prosecutor's Office, but every criminal matter is prosecuted in the name of the state of Ohio. And so the state may make a request to the judge or the magistrate regarding what bond it believes should be imposed based on the level of the offense. In the state of Ohio, there are 5 felony levels, and probably Mr. Shannon may talk about misdemeanors, but I'm going to focus on what I do with my court. There are 5 felony levels, 1 through 5. 1 is the most serious, 5 is the least serious. And then based on that range, based on a defendant's prior history, if there is a history of contacts with the justice system, there is a determination that is made regarding what bond should be set. There is something called a recognizance bond, which is essentially the defendant promising that he or she will appear when required to appear. We are trusting them essentially to show up when we give that next court date. There's something that's called a surety bond or an appearance bond, and it requires a defendant to put down a percentage through a bail bondsman to ensure that they will appear at future proceedings. So that all happens at the arraignment process, where that bond is set, a plea is entered. From there, we begin kind of the trial process, and when a matter is then assigned to a judge, there is what is called the exchange of discovery. That is really the heartbeat of a case, the information that the state believes will prove that a defendant is guilty beyond a reasonable doubt. There is a criminal rule 16, that requires the state and the defendant to exchange that information so that each side is aware of everything that is at play as the process moves through the system. Once the parties have exchanged all of that information, once each side has an understanding of the other side's respective positions, that's the time during which the lawyers begin to discuss plea negotiations, if that is even an option. Plea negotiations are solely at the discretion of the prosecutor or the state of Ohio. It can decide if it wants to reduce charges, let a defendant plead to a lesser included offense. Let's say if it's indicted as a felony of the first degree, which is the most serious, the state could offer the opportunity to perhaps plead to a felony of the second degree. That is totally within the purview of the prosecutor. Neither the defense lawyer or the court even has the ability to influence the state to offer a plea agreement. And so we start to see initially what the balance of power is as we are working through the justice system. And so those plea negotiations take place. The court is always available to assist the parties with looking at the case from both perspectives, but really I cannot require or persuade a defendant to take a plea offer. Generally, what I do in my courtroom is if there has been a plea offer, I will review the plea offer with a defendant on the record. There is something powerful about hearing all of the potential consequences if that defendant takes a plea offer, if he or she decides to exercise a constitutional right to jury trial, hearing all of that information from the judge. And it's my responsibility to ensure that all of that information the defendant understands, and that if they decide to take a plea or enter a plea, that plea is made knowingly, intelligently, and voluntarily. So it's my custom that I will review a plea offer on the record, and I will ask the defendant, is it your decision to either accept or reject the plea offer, and then, of course, to exercise your constitutional right to jury trial? If that defendant decides that he or she wants to accept the plea offer, we then move into accepting the plea. There are a series of questions that I am required to ask a defendant under Criminal Rule 11 to ensure that he or she is, again, entering a plea knowingly, intelligently, and voluntarily. Generally, that process takes about 10 to 15 minutes, where I ask, are they satisfied with their lawyer? Do they understand the charge against them? What's the highest level of educational attainment? Are they currently on any drugs or alcohol or anything that might impair their ability to enter a plea? I go through all of the possible penalties if I accept that plea, from prison to probation. If they go to prison, I explain what parole or post-release control looks like. And then I discuss any ancillary consequences that might be attendant to that offense, in reference to fines, driver's license suspensions, any other ancillary issues that might arise. And once I go through that colloquy, if they tell me they want to enter a guilty plea, I'll accept the plea, I'll enter a finding of guilt. The lawyers have the opportunity to decide whether or not they want the court to order what's called a pre-sentence investigation report. That report tells me all about a defendant's family background, mental health background, use of drugs or other substances, employment background, the facts of the case from the perspective of the defendant and from the perspective of law enforcement. I take all of that information, I then reconcile it with the factors for felony sentencing that are outlined under Ohio law. There is generally a range of sentences that is associated with each felony level. In some instances, prison may be mandatory based on what the legislature has written. And so there is a measure of discretion that the court has in determining what the sentence will be. And that's where the pre-sentence report and those factors for felony sentencing come into play. If a defendant is convicted at trial, he or she exercises that right to jury trial, and they are then convicted, found guilty. Once I sentence them, I then have to notify them of their appellate rights. Anyone convicted at trial has an automatic right of appeal to Judge Beatty Blount's court, the 10th Appellate District. I notify them that the notice of appeal will be filed, that counsel will be appointed. If they can't afford counsel, that they will get copies of all records associated with proceedings. Those will be given free if they cannot afford those records and those transcripts. And then I ask if they need for the court to appoint counsel. And I know that is a lot of information that I've given in a very compressed period of time. And I'm sure that my colleague, Judge Beatty Blount and Mr. Shannon, are going to add context to that conversation. But there are a series of steps that occur, and the judge, if he or she is not the arraigning judge, does not get involved until almost at the end of the process. The Supreme Court of Ohio has said that from beginning indictment to resolution, it should take about 6 months to resolve a criminal case. If it's a murder case, that's not realistic. For some mid-level felonies, that's not realistic. And so the judge has the responsibility of ensuring that these things are coming before the court in a timely fashion. And sometimes it's a balancing act. I have an active docket of about 268 criminal cases. That's not counting the civil cases. And so every day I am managing or trying to figure out how I can do what I need to do in the most efficient way. So I'm going to stop talking because I feel like I've said a lot in a short period of time.
It was very informative, though. Thank you very much. Mr. Shannon, did you have anything that you would like to add to that response, which was indeed very thorough?
Well, it was brilliant as well. I mean, that is probably the best summation that I've ever heard of that process from the felony level all the way up through appeal. So I hope that was recorded somewhere, because that's a very in-depth discussion. What I can add is this. As far as from a mayor's court perspective, when someone gets a traffic ticket, first of all, what we're dealing with are misdemeanor offenses, okay? We're talking about misdemeanors of the first, second, third, and fourth degree, minor misdemeanor offenses, and what's also called unclassified misdemeanors. Unclassified misdemeanors and minor misdemeanor offenses do not have any possibility of jail. The misdemeanors of the first degree deal with up to 6 months in jail and $1,000 fine. Misdemeanors of the second degree can involve up to 90 days in jail and or $750 fine. And misdemeanors of the third degree can involve up to 60 days in jail and or a $500 fine. And an M4 can involve up to 30 days in jail and or a $250 fine. So when someone receives a traffic citation for, say, OVI, it's a misdemeanor of the first degree, or the what I'll call less serious criminal offenses, they're still serious, but they're not as serious as felony offenses. Those are also in the lines of assaults, domestic violence, disorderly conduct, menacing, those types of criminal offenses. Now, mayor's courts cannot have jurisdiction over certain types of offenses, multiple offense, OVIs, where there's been a prior conviction within the last 10 years. And also they can have no jurisdiction over domestic violence cases or cases where a protection order may be obtained. That has to be all filed in the municipal court from the start. But by and large, once a person receives a traffic ticket or a criminal complaint, they are hailed into the mayor's court. As the judge indicated, that is their arraignment, their initial appearance, and they can decide what they want to do with their case by entering a guilty plea, not guilty plea, or no contest plea. Now, if they do choose to have a trial in mayor's courts are not courts of record, okay? So their decision is not final. So as long as the person requests a new trial within 10 calendar days from the date of their conviction, they get a second bite of the apple. It's transferred to the Franklin County Municipal Court, and the proceedings start all over. Then it goes through the municipal court process as well. It can involve the arraignment process, again, getting set before a trial judge and going through that process that the judge mentioned earlier, which the Supreme Court has indicated takes about 6 months for traffic and or criminal cases. In any event, once it proceeds to that point, their avenue, should they choose to challenge a decision of the trial court in the municipal court, is to the Court of Appeals. So that's a kind of a quick version as to how it would proceed through mayor's court. But I'll let the judge take over from there as far as from the Court of Appeals.
And in your response, will you include, is the individual incarcerated or in prison or jail during this process?
Very good question.
6 months, the 6 months that you're referencing, are they in jail?
By and large, no, they're not. There are some cases where they would be. I will say in a mayor's court situation, it is a rarity that someone is actually incarcerated. Now, every mayor's court is a little different. Upon arrest, there are some mayor's courts that will not require an individual to post a bond in order to avoid being incarcerated on a jailable offense and going to an arraignment process. Many of the mayor's courts, such as Bexley, will summons the person to come into the mayor's court where they'll have their arraignment. And I think that is for a couple of reasons. One, I think it's probably a very smart thing to do because mayor's courts do not meet as frequently as, say, the municipal court of record that meets, every day of the week. And so someone that might get arrested on a mayor's court case, they may be unable to post bond. And if that's the case, I mean, usually they have to be afforded a hearing, not usually, they have to be afforded a hearing within 2 days. But someone could be, wrongfully detained for a period of time, given the fact that the mayor's courts, some of these courts are very tiny and they don't meet as often, and it's hard to get them into special sessions. Most of the mayor's courts in Franklin County, we don't have that issue. We can bring someone out. We have police departments that are able to transport folks. But again, by and large, most of the cases, as far as coming through the process, the person is out of jail and the bond issue doesn't really become a question. There are some jurisdictions that will require they have a bond schedule so that when someone is arrested of a certain level of offense, they're required to post a certain amount of bond on a predetermined bond schedule. And if they do that, they are not taken into custody and slated at the jail. And then they just simply come to the next mayor's court date for their arraignment. Did that answer your question?
Yes, it did. Thank you very much. Judge Beatty Blount, would you please talk to us about the appeals court?
The appeals court is quite a bit different than what's called the trial courts, which would be common pleas, general division, and municipal court. And it's different in that what happens is that if someone disagrees or thinks that there was an error made in the trial court, those initial courts, then they can appeal to the 10th district, and the 10th district has to do something with their appeal. Then both sides have the opportunity to file a brief, and then if they want, they can get an oral argument. And an oral argument, each side only gets 15 minutes. And where trial courts sit just one judge at a time, appellate courts sit in 3 judge panels. So whichever 2 agree is how the case is decided. After that is where a big difference comes in, because you've heard, of course, of the Ohio Supreme Court. The Ohio Supreme Court gets to choose what cases it accepts. And I think they only accept 5 to 6% of the cases that they are asked to review. So for that reason, a lot of times the cases stop at the appellate court level.
I want to thank you all for doing an incredible job of conveying really how a case proceeds. That was awesome. So I know that we're just gonna jump right into the nitty gritty here. One of the questions that we were thinking about is the charges that have come about because of protests for people advocating for Black Lives Matter. As a public defender, I can say I've seen firsthand people charged with curfew offenses, riot, obstructing official business, disorderly conduct, amongst others, jaywalk violations. So I guess I will ask if any one of you have a burning desire first to respond to what do you think about these charges that have been brought? And I realize, as an attorney, I realize that if a case is before you, you can't comment on that particular case. But just in general, if you could give our community an idea of what you think about those charges.
Well, Becky, I'll chime in just because I can talk to you about a recent experience, which has been a very positive experience for me personally and professionally with respect to this issue. And for the city that I represent, and that's the city of Groveport. I will tell you this, that first of all, it is very important that the First Amendment right be permitted so that individuals have a right to protest issues such as this. The whole idea of petitioning the government for a redress of grievances and all of that is the core of this process of ours, and it's the core of the founding of our nation, obviously. So in Groveport, we were contacted by a resident who also happens to be a pastor, Pastor Crenshaw. And he has a church out on the east side of Columbus, Reynoldsburg area, but he's a resident of the city of Groveport. And he indicated on a Facebook site that he was planning on doing a protest, a Black Lives Matter protest, and he wanted the opportunity to avail himself of his own city to be able to congregate and be able to express themselves. And so what our department did and our mayor did, which I think was very effective, is they reached out to Pastor Crenshaw and said, would you like to meet with us and just give us an idea of what you would like to do and how we can help facilitate your First Amendment rights for you? And he was very receptive to it. Now, initially what they had talked about doing was going down a median strip, grass strip, on State Route 317. in Groveport, which would have been a very dangerous thing for the participants. And he understood after we explained that to him. And so what we indicated was, you know, why don't you consider using our main street? You can have folks gather together, and you can, you know, do a staging area at the larger parking lot near Kroger's there. And then obviously you can do whatever you would like, but we will assist you if you want to go down Main Street. And actually went all the way out to our rec center. And by all accounts, it was a very positive process, but it involved communication, and it involved people coming together and just saying, okay, people have a right to their First Amendment rights. And is there a way that we can work together so that these things can happen without anyone getting hurt? And so from my perspective, I thought that was a very successful situation. They've actually had two events that they conducted in the last couple of months. And you know, it's been a very positive experience. I think as a prosecutor, you know, yes, I have an obligation to prosecute offenses, but we also have to keep in mind individuals have a right to exercise their constitutional rights. And you have to have a violation of law in order for there to be a prosecution. So with respect to the charges that you've indicated, assuming that there was probable cause to file those charges and to proceed with prosecution, that's one thing. But if individuals are just exercising their constitutional rights, those don't rise to a violation of law and should not be prosecuted.
And Becky?
Yeah, Becky, I can't comment on specific cases because they could be appealed to my court, but I will say, just make an observation. Generally about what I've noticed happening across the country is that, you know, as Mr. Shannon stated, it is completely lawful to exercise your First Amendment right, but there's a couple places where I think some people think things go wrong. And those are when the protests are accompanied by people who are doing illegal things. And also when people who are lawfully protesting feel as though they are being mistreated and or treated differently than people who are protesting for or against something else.
That's exactly right.
And I absolutely echo Judge Beatty Blount's sentiments. And I think, you know, we'll just take a dive. I'll take a dive off the deep end since we're talking about systemic institutionalized racism. And more specifically, what I would say is that when you think about the protests associated with regulations associated with COVID-19, was there the level of outcry regarding those events and any alleged criminal activity? And I think that's where the challenge arises and why these kinds of conversations become necessary, because as Judge Beatty Blount said, the appearance of inequity creates a level of hostility and a level of frustration. I certainly advocate for the right of law enforcement to do the jobs that they are sworn to do. But I think where people are frustrated is that there is the appearance that there is a level of inequity about who is challenged and when they are challenged and how they are challenged. And I think that the second part of that conversation is the question was framed in the context of protests associated with Black Lives Matter. And as Judge Beatty Blount has pointed out, are those illegal acts associated with that particular movement? Are those actors persons who have at a certain level infiltrated to create a perception that the larger movement engages in criminal behavior? So I think we have to just kind of call a thing and be willing to say that there are some glaring inconsistencies that give people pause.
I think also you can't talk about this without looking at the history of it. And I understand a lot of people don't want to look at the history of it, but I would argue to you and anybody else that throughout history, how Black people come to you today is with the stories of our parents and our grandparents and our great-grandparents, where the law, particularly the Constitution, has not been applied equally to Black people. You can go, I mean, you start with we the people, did not mean everybody. It meant white male landowners. It left out a lot of white males even initially. And then you can just go through, down through, like, you know, the First Amendment. We admire Martin Luther King Jr. now, but don't forget a lot of the things that he was saying in exercising his First Amendment right landed him on the wrong side of J. Edgar Hoover's list. You know, you talk about things like the Sixth Amendment that guarantees, you know, the speedy trial and an impartial jury and confronting your witnesses and all of that. But we grew up with the stories of like Emmett Till, that some really bad things happened to him for whistling at someone, which, as far as I know, has never been codified as a crime in the first place, much less him being afforded all of those rights that are in the Sixth Amendment. So you come to modern times and you look at the protests going on around the country, and when people feel that they are exercising that First Amendment right that they learned about in school, that they see another group that's treated differently for doing the same thing, and that's where things go wrong.
Yeah.
Mm-hmm.
Thank you for those very thorough responses. I'm going to move on to our next question, which is related to your responses to the previous question. And I'll start with Judge Cocroft. And then we would appreciate everyone to respond to this question. Do you believe there is bias at all levels of the legal system, from deciding who to arrest, what to charge, and the length of sentences? What can be done to ensure a non-discriminatory system? Is there anything that can be done to ensure that? Ma'am?
Well, I think the most important thing for me to say is, as judges, what I feel necessarily doesn't really matter. We are taught that our emotions are not to influence any decisions that we make. I think what is more telling is that statistically, we know that there is a level of bias that exists in the justice system. Just a few months ago, our Chief Justice Maureen O'Connor wrote a missive, what I call a missive. It was a statement that she issued on July 4th that chronicled the history of inequity in the criminal justice system. I just participated in the judicial conference on last week, and Judge Donald, who's a member of the Sixth Circuit, talked about inequities that exist just based on skin complexion and skin tone. And I'm sure that the audience members have read Professor Alexander's book, and she goes through all of the inequities that exist regarding persons who are stopped, persons who are arrested, how charges are indicted, how sentences are imposed. So there are documented instances where Black individuals receive longer sentences. And really, if you think about it, that was kind of the genesis of the war on drugs and what we saw in terms of minimum mandatory sentencing related to the crack cocaine epidemic and the whole evolution of 2 strikes, you're out in Georgia, and 3 strikes, you're out in California, and those lifetime tails that were created when we know that scourge in the community was primarily concentrated in the African-American community. Conversely, if you look here in recent times and the opioid epidemic, there is now a leaning towards treatment as rehabilitation versus sending people to prison. And we know, just based on the population, that there is a huge constituency of persons who are dealing with the opioid epidemic who live in suburban communities. And I actually was at a continuing legal education event, and the chairman of the criminal committee in the Senate spoke, and he was talking about legislation that was coming through that would address the opioid epidemic. And he said, he was a white gentleman, I'll say that candidly, and he said that his neighbor's son was having a challenge with opioid addiction. And he said, I just couldn't believe that he was facing this challenge. He grew up in such a nice family. And there was a level of compassion that he expressed associated with knowing someone who was facing that crisis very specifically. And so I think that, yes, it's documented that there are levels of bias that exist, even though the law requires, in terms of sentencing, that judges treat similarly situated defendants similarly when we are imposing sentences. But if you look at how the disparities exist for sentencing someone for crack cocaine versus someone who possesses powder cocaine, there are inherent inequities that were written into law that didn't give judges a lot of discretion. And I could go on, but I definitely would like to hear from the other panelists. So my answer is not based on what I feel, but statistically, what we know, what has been documented around the country is that those inequities exist. And I would also encourage all of those who are listening to take a look at a report from 1999 that was completed by the Ohio Supreme Court dealing with racial fairness. And it documents clearly all of those inequities that exist, not just for litigants, but for lawyers and how they perceive that they are treated, for judges who are ethnically diverse and how they perceive that they are treated. So I would encourage everyone to take a look at that report. It is on the Ohio Supreme Court's website.
I would say that bias can come in many points in the process that Judge Cocroft outlined. And if you look at that process, it builds on itself, essentially. So for example, if you have someone with a bias or a prejudice that is the 911 caller, that person is telling the dispatcher what they believe to be true, who is then telling the police that same story. And so that can affect even what the police are thinking when they show up to wherever something's going on. Also, another example is, for example, if there is a bias or racism in how someone is indicted, once you go through that discovery process that Judge Cocroft was talking about, that person who was indicted under the darkness of bias is in a different bargaining position once the plea bargaining starts. So they're starting from a completely different position and even trying to negotiate through the system. So, and the other thing that I want to point out is that, don't forget, the criminal justice system is more than just the police. The criminal justice system is the police. It includes the police chief and the safety director that are appointed by the mayor, who is elected. The sheriff that runs the jail. Talk about how people are treated while they're incarcerated. The sheriff is elected. You talk about prosecutors. In Franklin County, of course, you can't have one person do every case. So you have an elected prosecutor that then hires assistant prosecutors. Who that prosecutor is and who that prosecutor hires matters, because it's going to influence how they are going to see each case. It's going to influence who they indict, how they indict them, and what for. It's going to even influence what jurors they strike off of a panel. And then you also have judges. Judges are making decisions not only about sentencing, but they're making decisions about what evidence comes in, what doesn't, who can testify into what, and lots of different things. So it's a lot more than the police. It's the police, it's the judges, it's the prosecutors, it's the sheriffs that are all involved. And if any of them have any type of bias at any point, it can lead to a negative outcome or an unfair outcome.
I concur wholeheartedly. And what I'd like to say is focus on what I can do as a prosecutor, because I think that both the judges have very adequately discussed, does it exist? And clearly it does. Okay, so we know this. What can I do as a prosecutor? Well, there's two avenues here. One is, the first is, and I've never had this happen to me, and I've been prosecuting since 1994, so I guess 26 years. That is, the prosecutor knows that during the charging process that racism was involved, okay? I've never had that experience, but if a prosecutor knows that, our obligation, the oath that we take, is what? Not to get a conviction of the case, it's to do justice, right? So we take an oath, and if you take that oath seriously, as you should, then if you learn of that, you have to act, and you have to act immediately. And that is, you dismiss the case, or you don't even let the charges be filed if you're in a position to do that, okay? That's the first one. The second situation is, let's say you don't know, you haven't been told, you haven't seen or observed anything which causes you to conclude, okay, something from the start was wrong here. But during this process, you evaluate the case. And remember what your oath is as a prosecutor. You have to promote justice. So you look at this, and if things aren't adding up, or if the case is just a very poor case, if there is a lack of documentation on the part of the police department, if there's something awry here, one of the judges spoke earlier about the prosecution. That's where we should utilize our discretion and talk about plea bargaining the case. By and large, I think that most of my colleagues on the prosecutor side of the aisle are extremely fair and do their very best for justice. You have to take that oath seriously, and within this context, you always have to be on guard. It is your job to protect everyone, okay? Everyone. And there are those instances where someone is wrongly accused, or there are two sides to every story, and the story that you're hearing from one side just isn't making sense. And sure, you can say things like, well, I don't believe I can prove the case beyond reasonable doubt, and those kinds of considerations. But you're not in it just to simply put a notch in your handle and get a conviction. That's not what we signed up for. So that's all I can add to that.
Hey, Becky, if I could add, I think to the second part of your question about what people can do, I think a lot of people have a misconception that in order to make any type of change, they have to do something really big, like they have to join the police force or they have to run for judge. Sure, all of those things are great. But as I was outlining, I was telling you all of the people involved in the criminal justice system who are elected. So you can implement change by educating yourself about the candidates and voting for the candidate that believes in the same thing that you believe in. The other thing that you can do is answer your jury summons. You have no clue how many times I have been called by friends trying to get out of jury service, which I'm never going to do, tell you. But because a lot of people don't realize that, especially in a criminal case, if a defendant decides to have a jury trial, it's the jury that decides guilty or not guilty. What happens is the jurors are picked. They go through a process from, opening statement to hearing witnesses, seeing exhibits to closing statements, and then they get jury instructions, and the jury instructions have the law in them. And what the judge is doing is saying, okay, you've listened during this trial decide what and who you believe from the trial, and then apply that to the law that's in these jury instructions. And you, 12 people on the jury, unanimously decide if this person is guilty or not guilty. So you can do a lot by even just answering your jury summons. I have talked even a lot in my own community, because you hear people say, oh, well, that person was convicted by an all-white jury. And they're saying that critically. But if we're not answering our jury summons, that's going to happen. Because as a judge, even, there's nothing that I can do unless there was some type of error in the way that the jurors were picked, which is not common because they're picked so randomly. And I'm talking about the big jury pool, not the actual jury that's seated on a case. But so if Black people and all types of people are not answering jury summons, then you're never going to have a jury that is representative of the county population. So 2 things, easy things you can do: answer your jury summons and vote.
And let me add quickly, jurors are selected from registered voters.
Yes.
So you're not ever going to be called unless you're registered to vote. The other thing that I would add, as Judge Beatty, Blount, and Mr. Shannon were talking, and we're talking about all of the people who impact the system, legislatively, those at the Ohio State House decide what the parameters are for me in terms of sentencing. They write the law. They set the bookends for what I can impose in terms of sentencing. And I'll tell you something that's a unique feature that goes to the issue of systemic racism. We're talking about the difference between crack cocaine in the 80s and 90s and the opioid epidemic that is currently facing our communities. There is currently a piece of legislation. It's called Targeted Community Alternatives to Prison. Within that legislation, the focus was to deal with people who were in possession of some illegal substance or some prescribed substance. That legislation says that if that person is pleading to a felony of the 5th degree, the lowest level felony, they cannot be sent to prison unless they are pleading to a sex offense, an offense of violence. They have a prior conviction for a sex offense or an offense of violence. And so what happens, maybe intentionally, unintentionally, is that you are eliminating a population of people who may be in the throes of opioid addiction. They are never going to be subjected to a potential prison sentence. And so we again start to see the disparities that exist for how justice was administered when the drug of choice was crack versus how justice is written and administered when the drug of choice may involve some kind of opioid addiction. So that's just a quick point that I wanted to make.
And enough to your point, Judge Cocroft, even though those disparities were technically fixed in the law, it's not like the people that were the victim of those disparities were let out. So you still have a generation of people that are eventually going to be released from prison, and they're facing all of the barriers that come with having a felony on your record. I would argue that number one is getting a job. And so another thing that people can do is, if you see that someone has had a felony, don't in the trash. Now look, I'm not telling you to hire someone who was convicted of embezzlement as your CFO. That's not what I'm saying. But what I am saying is that to reduce the risk that those people will go back to jail, we need to give them jobs. We need to set them up so that they can succeed. And so that's what, if you own a business or know someone who does, or if you're involved in HR, don't let a felony be an automatic knockout. Because the other thing that I've seen, and I'm sure Judge Cocroft has seen too, is that, certain convictions cannot be expunged. You can't get them sealed. So we have seen people paying at 40 for what they did at 20. And, as far as getting a job and, even how they're just seen in society, getting a loan if they want to start a business, getting housing, all of those barriers, you know, once you have that scarlet letter F, you know, they are real and they are very long lasting.
I am blown away with your honesty and knowledge, and I'm so thankful that you all have answered these questions. Really, I know how much it means to me, and I'm sure that everybody, that's my reminder, it's 8 o'clock. I'm sure that everybody who is watching is absolutely appreciating this as well. On a smaller level, I wanted to just point out, Kevin, you've been the Mayor's Court prosecutor in Bexley for how long?
A little over a year.
And I'm just curious, just on our level, if, you know, if you could just, I'm sure that you've made changes or seen changes in the year that you've been here. And I just wanted to know if you could maybe dive into that a little bit related to this.
Sure. I don't know how things were conducted before I got there as prosecutor. I think that we do a very good job with respect to the administration of justice in our mayor's court. And I think a big component of that was providing a public defender for individuals that have been charged with an offense. Now, we have to all understand our roles. You know, the judges understand their roles very well, and the prosecutor has to understand their roles, and they don't really want to get into the situation where they're giving legal advice to the defendants, because obviously we're prohibited from doing that. Be that as it may, a lot of these folks that come in just need someone that they can talk with and explain what's going on with them with respect to the kinds of cases that we deal with, which are by and large licensing cases and things of that nature. And so Mayor Kessler took a very, in my opinion, a very proactive approach, because you have to understand, you don't have typically public defenders in mayor's courts. It just doesn't happen. Their individuals will sometimes bring their own lawyers with them, which obviously they are entitled to do, but there's not a public defender system that's set up for the mayor's courts. And so the cities, if they want to or elect to do that, they have to contract with an attorney to provide those services. And we have an exceptional lawyer that is doing a great job for the city of Bexley with respect to providing such representation to individuals that are charged, and Leslie Albright. And she is fantastic. And yes, we do have to go through our dueling at times, because that's the system in which we're in. I'm the prosecutor and she's the defense lawyer. But the point is that we both have a job to do. And at the end of the day, I think that we've provided a very fair forum for individuals to resolve their cases in Bexley Mayor's Court. So that's been the biggest change. And that's not done in every mayor's court. Now, a lot of the recovery courts that are being set up across the county, in Hilliard, there is a recovery court in Hilliard, and there's a public defender that's on contract there as well. He does an exceptional job. And so I think that is a very, and a trend that I'm proud to be a part of, quite frankly. I think it's essential that folks just have an opportunity to go into a closed room with someone that's advocating for their interest and cares about their interest, because, you know, they come in, they talk with me, and they're indicating what's going on. They understand at the end of the day, because I tell them, now, you know, I'm the guy who's prosecuting you, and you got to be careful of things that you tell me, because I can use those things against you. You understand that? And so that kind of gets people a little unnerved, and it should. And now we, at least in the city of Bexley, have an opportunity for individuals to go and talk with our public defender. So as far as other changes, I just think one of the things I did, and I'm not tooting my own horn here, but in what we deal with as far as mayor's courts and municipal courts, probably the most overriding charge is driving under suspension cases. And the judges talked very eloquently earlier about types of legislation that gets into place. Let's look at the driving under suspension laws and how they were set up, okay? And basically, in my opinion, and I'm probably going to get in trouble with the insurance industry over this one, but you know, it pretty much set up a debtor's prison, right? Because once you got into BMV hell, you weren't going to get out. You get these suspensions on your record. They're getting charged, and then of course there was case law which allowed officers to simply run license plates, and if the driver of the vehicle matched the description of the individual that was said to be under suspension per the leads printout that they have on their mobile data terminal, well, they could pull them over and they would write them the ticket. So you start seeing all of these cases coming in again and again and again and again. All right. Well, we need to do something about this, right? These folks are making a decision to feed their families and go to work, and they can't afford $2,000, $3,000 reinstatement fees. And I understand that there's amnesty programs, and those are very good. And they set up payment plans, thank God, that at least gave some people the opportunity to do so. But at the end of the day, all right, again, what did we sign up for? We signed up to try to resolve these problems, and at least on my end, to do justice. And I've had these conversations with chiefs of police, and I'm very fortunate with the chiefs that I've represented in Reynoldsburg, Groveport, and now in Bexley, their departments. You know, I'm able to convey this, and we don't always have to agree with this, but they do agree with me on this one. What did we sign up for? We did not sign up to just simply write tickets and keep people shackled in BMV hell. Okay, we've got to give them an opportunity to get their driver's license so that they can get a better job, so that they can drive and not drive with a cloud over their head and wondering. Now, I'm not talking about folks that are driving under OVI suspension. I'm talking about these dreaded FRA suspensions and security suspensions and license forfeiture suspensions. We've worked very hard, and by having a public defender now in Bexley, be able to actually sit down with individuals, go through their record and say, their driving record, say, this is what you need to do. Come up with this type of money for this payment plan, come back valid. And then you come to me, what can I do? Well, I can dismiss the case. I can dismiss the case and let them pay court costs. Because if I have to have that conviction, guess what? They have to show insurance. And if they don't have insurance, which they're not going to have insurance, right? Because they're making a decision to feed their family as opposed to pay the insurance bill, well, they're just going to end up in BMV hell. So we dismissed the case for costs, and I want to tell you that I cannot think of an individual that's come back before me that's obtained a valid driver's license and then comes back to, 6 months, a year later, and they're under suspension again. Okay, so this is the kind of effort that we need, and this is the kind of progressive effort that I think that we've undertaken in Bexley. And I've tried to do it in the courts where we don't have public defenders and talk with people as much as I'm permitted to in the law and explain to them to go to the BMV. But there's nothing better than having someone that is your lawyer, all right, being able to explain things to you, actually maybe possibly make phone calls for you and get you back with a driver's license. Because our clerk in Bexley, Ruby, I saw her say to an individual the other day, she said to a young man, she said, "Don't you feel better?" And he just smiled. He felt, for 5-6 years he'd been dealing with, having very low paying jobs because he couldn't drive. All right. And now he's valid and he's getting a shot. And I think that's what we're about clearly at the mayor's court level. And I'm very proud of that. And I'm very proud that the mayor did this with respect to having Leslie come aboard. I'm sorry for going on with that, but I got really passionate on that one.
Thank you. Thank you very much. We really appreciate that thorough explanation. And I'm just going to say that in the interest of time, we do have a number of questions that have come through the question and answer chat. So we're going to try to clip through those pretty quickly and then wrap up promptly at 8:30. So instead of going through all three of you for the next few questions, we'll identify one person to answer the question so we can try to get through these remaining questions. So Judge Beatty Blount.
Yes.
Blount, excuse me. in your observation, has there been a requirement for members of the justice system to take implicit bias or cultural sensitivity training? If so, how would it have, or how has it changed how you do your job? Was that clear?
Yes. For us judges, where most attorneys have to get 24 hours of CLE, of continuing legal education, judges have to get 40. 10 of those have to be from the Ohio Judicial College, and Judge Cocroft helped me out here. I believe 3 hours have to be
Yes.
access to justice.
Yes.
The access to justice covers issues regarding race, issues regarding even issues around having interpreters in your courtroom, issues dealing with people with physical disabilities. So we are required to do that, yes. I always think that it's helpful, and here's how. You know, I even have to admit that I have my own biases. And so, you know, and I think everybody does. The key though is to, one, recognize it, and once you recognize it, you can check it. So that's how those CLEs are always helpful to me, because in all candor, even in dealing with the opiate epidemic, you could have a sentencing day where you have one defendant who, you know, grew up very poor, did not have access to a good education, did not have parents who treated them properly as a child. They might have mental health and substance abuse issues, which really, really, really narrows the option of where a judge can send them for help, versus the person who might be right after them that comes from an affluent suburb with 2 working parents and they have insurance. And so sometimes it's like, you can say, well, to the second person, what's your problem? Because you don't have it as bad as the first guy. You know, it's human, but you have to recognize it and you have to check it so that you are treating everyone equally. You are looking at every case as its own case and every individual as their own individual.
Thank you.
Okay, so one of the questions that came through on the Q&A is if you could speak to how the justice system failed Breonna Taylor.
That's a huge question. And I think that the best starting point, and again, I want to be very careful because as Judge Beatty Blount has said, we have a responsibility not to get too deep into the weeds. Here's what I will say. There is an old saying, an old maxim, that if a prosecutor chooses to do so, he or she can indict a ham sandwich. It's very easy because it's a lopsided process. It is simply the state or the prosecutor presenting evidence that he or she believes substantiates a charge that he or she believes is appropriate given the evidence and the facts as he or she understands them. So not having been in that presentation, I will say that I felt as though the press conference that explained the grand jury's decision was a little too involved because those are supposed to be secret proceedings. And so I felt as if there was information that was given to the public that was used to justify an outcome. And that's not really the responsibility necessarily of the prosecutor. It's just to present the evidence as it exists. From what I've heard, I know that there are inconsistencies about who may have heard what and who did not hear what. And so I think that when we start to politicize legal decisions, we create the environment that we see is manifested here. And I know that I'm speaking very tenuously and artfully, but I find it very curious that there are between 36 to 40 shots discharged in her property, and that the charge that was indicted is associated with those shots that landed at another property. I also find it curious, and if I were inquiring, if this were at trial and the judge is permitted to ask questions at times, I find it curious that there was no decision to review the warrant itself, because that was the catalyst for the interaction. And so if the warrant wasn't sworn out with an affidavit that's substantiated or corroborated, even going to that home, I would think that that was something that a prosecutor may want to address. And so it's a challenging decision. And let me say this, and this is kind of off topic. I think sometimes there's a belief that because Judge Beatty, Blount, or Mr. Shannon or other people are a part of the system, that we are somehow disaffected by what happens. As a Black woman, I am challenged daily to do the work that I do and present the way that I present. My last name is Cocroft. And so if people haven't met me, they are surprised when they meet me that I'm a Black woman, because it doesn't sound as if I might be a Black woman. And so I am then having to prove that I deserve to be in that position. Whereas for others, competence may be presumed, my competence has to be proven. And so getting back to the original issue, I think that all of us are affected by what we have seen, because it makes our jobs tougher. There is the thought that we will perhaps operate in a way that doesn't display a level of fairness and impartiality. And for me, that's probably one of the biggest takeaways.
I agree with Judge Cocroft. Every judge has also had a case where they experience, it's hard for the media to tell the entire story. My questions about the Breonna Taylor case would be about the warrant, and they would also be about the grand jury process, what was presented to the grand jury. I also agree that my worry that is coming out of the Breonna Taylor case is the perception that Black women have of the justice system. Because right now, you just look on social media, there's a lot of Black women that are feeling like the police can just come in their place and shoot them. Whether that's right or wrong, that is the perception that they have right now. And so that makes it tough for the juries, for the justice system to work with a perception that it's so inherently unfair from the very, very, very beginning.
And I think also, if I could just say quickly, you have to reconcile the Taylor case with the case out of Minnesota that involved Justine Rusak, and I'm probably not saying her last name correctly. The officer involved was Mohammed Noor. And that was another instance where Justine approached the vehicle. The officer believed that there was some imminent threat. He discharged his weapon. She was killed. He was indicted. He was charged. He was convicted. He was sentenced. Justine is a white female. The officer was of African descent. And so when you see these cases paralleled, you start to wonder, what is the distinction? Mm-hmm. And so people are only left with so many options. And it's a very slippery slope if we start to allow that perception, as Judge Beatty Blount has said, to exist. We have to be honest, and we have to be accountable, and we have to look at the historical underpinnings of this country and how it is that Black people, brown people have been historically marginalized and overlooked, and how coded language was used to advance systemic racism. We have to be really honest about all of that.
Mm-hmm. I could add just a couple of things. The first, in reviewing this whole situation with Breonna, the thing that, first of all, there's a very good reason why many states have done away with no-knock warrants, right? This is this is a situation where a no-knock warrant executed at night, where you have someone, and I don't necessarily want to get into the weeds, but I have a concealed carry permit, right? I have a weapon in my home. If someone came blowing through my door in the middle of the night, I mean, I think I would be reaching for my weapon. I understand that there's factual considerations as to what was said. Was there, one witness heard someone say police, and then there were several witnesses that didn't hear anything said, just simply the busting down of the door. So that, I think the no-knock warrant itself is a very problematic thing to begin with. That's probably a topic for another day. But also, I think, which I agree with both of the judges as to, because the warrant is based on this information about these packages being sent to the apartment, and the post office was monitoring that. Then you have the post office coming back saying, no, wait a minute, no, there were no suspicious packages coming there. And so again, at the end of the day, can you conclude, a reasonable person conclude, that there was a thorough examination of all of the facts of this case? All right. I mean, that's all I want to say about that.
Well, if I could add really quickly, Mr. Shannon, and let's not forget, again, I keep harping on this, there's a lot of players in this system. Yeah. So, while the focus is on the police in the Breonna Taylor case, don't forget, they had to go to a judge to get that warrant.
Exactly.
And the judges are voted in.
At least in Ohio,
yes.
They are. I'm not sure about Kentucky.
Yes, that goes back to your point in the importance of making sure you vote. So we do have 10 more minutes or 9 more minutes. We have a couple of extra questions. We will probably not get to all of the questions this evening. However, I would like to point out that this opportunity to engage in a dialogue about this topic, systematic racism, about how our government works, about how we as citizens can participate in the process. This is one opportunity, and I believe that Monique Lamke and Jen Robinson have other opportunities planned in the future, so please keep an eye out for our next community awareness building engagement. So we're not going to end. I'm going to go ahead and ask one more question, and just one more, Becky, or do we have time for 2 more?
I have a feeling it's going to be 1.
Okay.
Are you saying we're chatting, Becky?
I love it.
I'm going to blend 2 questions that are similar and actually gives our community members an opportunity to figure out what do they do next. So do you have any suggestions for members of the Bexley community with regards to the criminal justice system? How can community members advocate to help change the system? And is there a specific call to action for citizens beyond voting and serving on juries? And since that is such a loaded question, we'll have all 3 of you respond, and then Becky will come in with closing comments.
Well, I would say, just because I can speak mainly from my perspective as a law director for Groveport, I think as far as the citizens, we've already touched on the importance of voting, but get involved with the community. Go to the council meetings, all right? Become aware of the processes of your local government. There's a whole legislative process. It usually involves there being at least 3 readings of any legislation that's being introduced before city council to be considered. There's a committee process, and there's an opportunity for the citizens to be heard on these types of issues. So this covers legislation that, obviously that's coming down the track that you may not agree with, and you want the ability to state what your concerns are and be heard before that 3rd and final reading. But also it gives you an opportunity to come in and address city council about those concerns or issues that you believe are at the forefront of your community, and that things that need to be addressed that you'd like to be looked at, whether it's, by the police department or whether it's, some other aspect with respect to, life in Bexley. But you have to get involved civilly in that process.
I would say, another way that you can advocate is at the State House. Because again, as I think Judge Cocroft or Mr. Shannon said, the judges apply the law, but it's the legislators at the State House that actually make the law. So paying attention and being involved, not only in voting, but in meeting with legislators and calling them and telling them what you believe is another way that you can help make change. Also, to be honest with you, I think that you all should be honest with yourselves about what's going on in Bexley. Having grown up in Columbus, I grew up close to Bexley. I went to school in Bexley. My first job was at the Drexel. And it is almost a given in the Black community in Columbus that you be careful driving through Bexley. And I'm not sure if a lot of people in Bexley know that, but you can ask anyone in the Black community, and that is what the majority of people will tell you. The other part of my answer is not as a judge, but as a mother, and that is to educate your children. And here's why. Because if my son is stopped by the police, he could have a very different experience than a friend who is white. And a friend who is white, who knows those issues, will not leave him. And so I implore you to educate your children, not only for the protection of their Black friends, but also because they are the future leaders. And even if we can make an incremental change right now, they're the ones that can make big change in the future.
I agree with all of those points. And I would say probably, and it's very generic, if you see something, say something. I think sometimes there's such a hesitance to get involved when we see inequities as they are taking place in real time. And if you are living a comfortable life that is, again, disaffected by systemic racism, sometimes it's difficult to step outside of that bubble and address some really challenging issues. And so often as Black people, we are asked to ally and to champion for everyone. We are asked to get on board, to support certain candidates, to support certain causes and issues. And then when the Black community is caught in a bit of a storm, we have to sometimes rally people to even acknowledge that the issue is real, that the issue exists. And I'll tell you candidly, I had a moment today where I was just tired of being a Black woman. I'm tired of having to explain what is a very real part of my life. This isn't something that we've imagined or created or that we've blown out of proportion. This is actually what is happening. I have actually had a conversation with my nephew when he was younger that no, you can't play with that toy gun because somebody might think that's real and somebody may call the police and the police may arrive and it may turn into a situation from which we cannot come back. Mm-hmm. And so I need for people to acknowledge, even if you don't understand, just acknowledge that the problem is real. You don't have to, necessarily, if you're not comfortable, I will say, with going to the State House and talking with legislators, talk with your neighbors, talk with people within your sphere of influence and start to have those difficult conversations. Charity starts at home and then it spreads abroad. And so as we build those conversations incrementally, I think we will start to see incremental change.
Absolutely fantastic. More than what I think we could have imagined. Now, I know I said I was turning it over to Becky so that she could close this out, but I really wanted to thank each of you again for joining this. I wanted to highlight what the call to action was. I took a few notes. I'm going to highlight what I feel is like the 7 things that came out of this last question, and hopefully we'll have these notes available along with the posting of the video. But number 1, vote. Number 2, attend city council meetings, get involved civically. Number 3, get involved at the State House, meet with legislators, and meet with your neighbors and your sphere of influence. Number 4, educate your children. Educate your children to be allies, and because they will be our future leaders. So help get your children informed. Number 5, if you see something, say something. Don't be a bystander that doesn't call out injustice, that doesn't call out inequities. When you see something, say something. Number 6, be an ally and acknowledge that the problem is real. And then number 7, I think someone said this, or maybe I just added it myself, but educate yourselves. Make sure you are an informed citizen, an informed person that goes to the polls to vote, an informed citizen that goes to city council and that goes to the State House. So those are my little added comments, because I thought that you guys did a great job highlighting the call to action, and I wanted to make sure everyone got it. Becky?
I am blown away. I truly appreciate the raw honesty and your gift of sharing to me. We really, really appreciate it. And again, I want to thank you, Judge Cocroft, Judge Beatty Blount, and Kevin Shannon. This has been a really big, impactful evening for all of us. So thank you so much. This is recorded, and it will be provided, it will be on the City of Bexley's website for future reference if anyone wants to see it or share it. Thank you so much.
Thanks for having me.
Thank you, City of Bexley, for being even open to this conversation. It is so critically important, so thank you.
Thank you. Good night.
Good night. Bye.
Good night.